Good morning, Mr. Warden. Are you ready to get started?
Yes, ma'am.
Okay. We're ready when you are, Judge. Thank you. He'll be right out.
This is another.
All right, good morning. This is People versus Deepak Adekari, file 211585SD. And Mr. Warden is here with the defendant. I take it that's Mr. Adekari next to you, Mr. Warden?
It is, Your Honor.
Okay, and this is the date set for a plea. Is that what your client still wishes to do? And was there any plea offer? And I'd note,
yes, Your Honor, that is what we would like to do. And the plea offer is to OWY operating while intoxicated, dismissing the high BAC.
All right. So, Mr. Chamberlain, is that a correct statement of the plea agreement?
Yes.
Right. And most importantly, Mr. Adekari, is that your understanding of the plea agreement as well? You'd be pleading guilty to the reduced charge of OWI, the original charge dismissed.
Yes.
Has anything else been promised to you, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
You realize, do you understand that by pleading guilty, you will have a conviction for operating while intoxicated, and that carries a maximum penalty of up to 93 days in jail?
Yes.
Hang on just a second, Ms. Odom. I don't have any of the folders in my
Okay, let me see if I do.
inbox. Okay.
Look at, like, let's see. Hang on a second.
We're all in criminal no-show.
Yeah, nothing must have been checked in.
Yeah, I can't see the folders. When they're
Ms. Casties? I'll have to send him a message. I don't have them either, unfortunately.
Okay, so Mr. Adekari, I need to go over your rights with you and make sure you understand all those before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. You understand those rights?
Yes.
You also have the right to have the witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses. And the court would order those witnesses to appear if need be. Do you understand those rights?
Yes.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand those rights?
Yes.
Finally, by pleading guilty, you give up the right to appeal you'd have if you went to trial. And any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to hear any appeal of your conviction or sentence. Do you understand those rights?
Yes.
All right, so is it your desire then to waive all those trial rights in order to plead guilty to the reduced charge?
Yes.
All right. Well, since I don't have the file in front of me, Mr. Warden, if you could voir dire your client to establish
Yes,
the
Your
basis
Honor.
for the offense.
Yes, Your Honor. Deepak, is it true that on May 15th of 2021, you were in Leelanau County in Northport? Yes.
Yes.
And is it true that you were operating a motor vehicle on North Mill Road after drinking?
Yes.
And is it true that you got pulled over?
Yes.
And after doing field sobriety tasks, you ended up having a blood alcohol level of 0.21. Is that also true?
Yes.
Is that consistent with the amount of alcohol you drank that night? You drank a lot of alcohol that night,
Yes.
and you believe it affected your ability to drive a motor vehicle?
Yes.
Okay. And that was in Leelanau County.
Yes.
No further questions, Your Honor. I believe that covers the factual basis.
All right. So then to the charge of operating while intoxicated, how do you plead?
Guilty.
All right, I will accept your plea. I find it's voluntary, accurate, and understanding.
Your Honor, I think there was just one spot that we missed on that plea.
Yeah, what was that?
Did he do a breathalyzer or did he do blood? I think that's just what we need to state.
It was a blood test, correct?
Yeah.
And the results were 0.21?
Yeah.
Okay.
Thank you.
All right, so again, I will accept the plea and find that it's voluntary, accurate, and understanding. I'm going to set this for a pre-sentence investigation report. I do have a counseling report already. Sentencing will be on Ms. Odom. You want to work with Mr. Warden?
Yeah. How about July 30th at 9:45?
That works.
Thank you.
All right, and if you could have your client call the probation office between 1 and 4 p.m. today to set up the interview, I would appreciate that.
I will do.
Is there anything else we need to take up today?
No, Your Honor. Thank you.
All right, thank you.
Thank you.
All right, we'll go to People versus Patrick Kolarik. And Mr. Kolarik, are you there? Is that you in the?
Yeah.
I want to say Hawaiian shirt.
Yeah.
Okay. I like it.
Yeah. Thank you.
All right. All right. So Mr. Williams is here on behalf of Mr. Kolarik and Mr. Chamberlain for the People. This is a date set for a plea also. And Mr. Williams, is that what your client wishes to do? And if so, is there a plea offer?
So my client does wish to plead. He also wishes to proceed to sentencing. I did provide the people and the press or the court with a substance abuse evaluation. I don't think there was an official offer. I was anticipating that the people let him plead to a visibly impaired. He had a blood alcohol of 0.13. He's 72 years old. The substance abuse evaluation does not indicate he's substance or alcohol dependent. There was an MSP blood draw, it was a 0.138 to be exact. So I'm hoping we can move forward in that direction.
All right, so Mr. Chamberlain, is there a plea offer? Sounds like we caught Mr. Chamberlain off guard a bit with the plea offer, so I want to give him an opportunity to look at the file. So take whatever time you need, Mr. Chamberlain.
Thank you.
I think while Mr. Chamberlain's doing that, we're going to move on to People versus Lisa Looker. That's set for sentencing this morning. And Ms. Looker is here with her attorney, Mr. Warden. You're still there, aren't you, Mr. Warden? Oh, I see his name, but he may be talking to his last client right now.
Your Honor,
This is set.
oh, he's on.
Yeah, okay, so Mr. Chamberlain, do you have a plea offer then or not in the Kolarik case?
Unfortunately, I don't. It's outside of our policy since there was a collision with an object, so there is no plea offer.
All right, so
If I could be put in a breakout room with my client, we still might be able to get this case resolved, Your Honor. So.
okay, so I will set that up. All right, Mr. Kolarik, you will need to accept the invitation to the breakout room. Should have popped up on your device there. All right, so let's again go to the Looker matter, and this is set for sentencing this morning. Mr. Warden is here for the defendant, Mr. Chamberlain for the people. Have you had an opportunity to go over the pre-sentence investigation report with your client, Mr. Warden?
I have, Your Honor. We've reviewed the pre-sentence report. We find it to be complete and accurate.
I did have a question. Was there an assessment done? Because if there was, it's not in my probation folder.
There was an assessment, Your Honor. It was attached to the pre-sentence report that I got. It was low-risk alcohol use based on the World Health Organization, and it recommended a brief intervention, which was one education session with her therapist, Sherry Hadfield, focusing on alcohol use, and she has completed that session.
All right. Did she have some proof of that today, a letter or something from?
Unfortunately, no. I mean, we could certainly give the court a letter, but this has been kind of a lengthy case.
Is that the psychotherapy intake?
So we've had several months of follow-up.
Yeah, I've got it right here.
Well, that's great, except that this court doesn't have all that follow-up. You know, I'm here for a plea or a sentence, I mean. And so anyway, Ms. Odom, I don't have the assessment.
Yeah.
I'm going to have to get a copy of that before I can.
Okay, I'm looking.
I'll scan it and
Don't
send
see
it.
it in that probation folder.
I'll scan it and send it over.
I have it. It's under correspondence. It's at psychotherapy intake, Coast Center for Emotional Wellness. Is that it, Mr. Warden?
Yes.
Thank you. Do you want me to print it, Judge?
Yeah.
Be right back.
Hey, Tristan.
Yeah, do we need to talk?
We'll just set it for another pretrial. I didn't mean to catch you off guard. I didn't realize that happened.
All right, so I'm going to go back to the Kolarik case. It sounds as though you want another pretrial conference, Mr. Williams.
I do. I don't think I had indicated at arraignment we wanted to set up for a plea. Somewhere in the shuffle, the people and I didn't discuss in between. But yeah, if we could just set up for another pretrial conference and move forward from there today, that would be very helpful.
All right, I just closed the breakout room. You're waiting for your client to come back here. Okay, so Mr. Kolarik, just so you know, what we've been discussing is your attorney would like another pretrial conference to talk to the prosecutor. So we're going to set that up. And Ms. Odom, do you have a date?
I don't. I'll just let Miss Casty's mail notice.
Okay, so Ms. Casty's going to take care of that. And is there anything else we need to take up today before we let Mr. Kolarik go?
No, Your Honor.
All right. Please feel free to sign off if you'd like, Mr. Kolarik. Okay. Sorry for the back and forth here this morning. We'll go back to the Looker case. I am reviewing the substance use assessment at this time. All right. So, Mr. Warden, have you had an opportunity to review the pre-sentence report and the psychotherapy report with your client? And is it accurate and complete?
We have reviewed those documents, Your Honor. We do find them factually accurate.
All right. And what would you like to say on behalf of Ms. Looker?
Your Honor, under the new law, this is a defendant that squarely falls in the presumption of no probation and no jail. Ms. Morton agrees. I want to echo her thoughts that Ms. Looker is truthful, emotional, and remorseful. Lisa has been, an A-plus client of mine. Some people want to hedge. Some people want to tell me that, it's the police officer's fault. Some people want to make excuses. I have not had that from Ms. Looker in any way, shape, or fashion. She has followed up with her counselor. She has been, again, I would just say very emotional, embarrassed, and remorseful. I don't think this court can do anything to her that she has not already done to herself. At 54 years old, very well employed, good mom, and this is, quite frankly, a blip on her radar. The PBT was 1-0. The data master was 1-1 and 1-2. Not gigantic numbers, but certainly not numbers that anyone should be driving around on because it's just not safe. And Lisa knows that. I think, again, this case has been pending since May. She's done very well. She's actually taken this extremely seriously. I agree with the recommendations wholeheartedly, especially with no criminal history at age 54 and again, very well employed. I would ask the court to simply follow the recommendations and give her fines and costs and close this case and admonish her again that this never happened again. And I know Lisa knows that can't happen again. She's made some very positive and proactive choices in her life. She reports to me that she's feeling, better about this situation, even though that it's taken a while to kind of get through the depression of, getting arrested. She seems to be on the right path, and I wholeheartedly believe you'll never see her again in this context.
All right. Thank you, Mr. Warden. So, Ms. Looker, is there anything you'd like to say before I sentence you?
No, I would just like to apologize to the court. I know that my decision that evening was not the best decision I've ever made, and I realized that I showed poor judgment and poor example. And like Sean said, I have learned from this and do not ever, I realize I'll never make a decision like that again.
All right. And the counseling session that you completed, was that with your regular counselor?
Yes, it was.
And that's someone you were seeing for some other issues. And does that person have any certification in substance use disorder training?
I would have to verify what all of her credentials are. And I had been seeing her for just a few months prior to this incident, just for some transitional work and family related issues. But I can certainly follow up and let you know. She is certified and she was recommended highly in the community. I'm just not aware of her credentials.
Okay, and there is a distinction between therapists who deal specifically with alcohol and drug issues and those who do routine therapy. And so anyhow, so Mr. Chamberlain, is there anything you'd like to add?
Your Honor, I have no objection to the recommendations of probation.
Okay. All right, so this is sentencing on the defendant's conviction of impaired driving. It was originally a operate while intoxicated case. The facts are the defendant was celebrating a birthday at the restaurant, had too much to drink, was pulled over for speeding, 16 and a 55. And there was a data master test that showed either a 0.1 or a 0.12 blood alcohol or breath alcohol concentration. The defendant is remorseful for her actions. She's embarrassed, I can tell. She is, to her credit, she has no prior criminal history. She is well educated and well employed and professional, and does see a therapist who she's been counseling with, not for alcohol issues, however. And the assessment does indicate that this does not appear to be any type of dependence issue.
Your Honor, I have his credentials.
You do.
Yeah, it says he has the highest certification in the state for addiction counselors.
Who are you talking about, Mr.?
Jacob Rossi out of Third Coast Counseling, which is where this psychotherapy intake note came from. And
Okay, but is he the one that did the counseling in this case, Mr. Warden? Because what I got was that she's seeing her regular therapist who she's seeing for some other issues, and not Mr. Rossi for the educational session.
He did the intake, Your Honor. He did not do the follow-up session, but I can't imagine that he would have recommended the follow-up session if he didn't have, some level of confidence that her counselor could handle the topic matter. And again, without dependence, my personal prerogative is when I don't have a client with dependence, I like to see my clients talk about triggers, talk about, other issues in their lives that can lead to stressful events, that can lead to then, obviously poor choices of drinking, and then obviously poorer choices of drinking and driving. So no, the follow-up was with Sherry Hadfield. And that did focus on alcohol use, but I don't know her credentials. But I would also suggest that, again, she has followed up with the recommendations, and I would ask the court just simply allow her to continue counseling outside of the court system with fines and costs.
All right, so given the recommendation in this case, I guess my frustration is I've got a sentencing right after this on Mr. Pabuda. It seems to be the case that depending on which counseling service you go to or assessor that you go to, makes a big difference what the recommendations are. Mr. Pabuda, who's set to be sentenced here this morning, is in pretty much the same position. I don't see any CCH. It's a conviction of impaired driving. There's no substance use disorder, but there's a recommendation for alcohol, highway safety, and victim impact panel, which I think would be helpful in any OWI case. Nevertheless, Ms. Looker, on the other hand, is seeing a counselor, and that's not something that's been recommended in Mr. Pabuda's case. But all right, so this is what I'm going to do. I do believe that having no prior criminal history, being 54 years old, and being professional and having been arrested, she was taken to jail. This is obviously a big wake-up call for Ms. Looker, and the conviction and the arrest, I think, are sufficient in this case to hopefully make sure that Ms. Looker, who does not have a diagnosed problem with alcohol, will not do this again. And therefore, I'm not going to place Ms. Looker on probation. There's a presumption against probation unless there's a rehabilitative need for that. Apparently, she's done the counseling that was recommended by the assessor. And so I am going to impose standard fines and costs. That's a $100 fine, $800 cost. Crime Victims Fund fee is $75. Judicial system fee is $50. And, there's no arresting agency fee. That seems unusual. Isn't there usually an arresting agency fee for the sheriff's office? Or let's see, this would be the Grand Traverse.
It'd be Leelanau County, Your Honor.
This was Leelanau County. Okay, so is that $125 typically, Mr. Chamberlain?
That's what I believe it is.
Okay, so $125 there. All right, there's also credit for 1 day in jail. And let's see. Is there anything else for you, Mr. Warden?
No, Your Honor, thank you.
Okay, Mr. Chamberlain, anything else?
Thank you.
All right, and Ms. Looker, hopefully you have decided this was a bad idea. I see where you told the probation officer no more drinking and driving, and hopefully we never see you back here again, and I wouldn't expect that. So thank you. We're all set for today, and feel free to sign off.
Thank you, Your Honor.
All right, let's go on to People versus Pabuda. There he is. I want to check. I see there's Jody on the line there. Good morning, ma'am. What is your last name?
Ferguson.
Ferguson, okay. And which case are you here on?
21-7087-LT1.
We don't have it on our docket.
I do not have that on my docket, and so I'm not sure what the what's happening with that case. Perhaps it was dismissed, or are you in Leelanau County?
Grand Traverse County, and it's a landlord tenant, and it was resolved like, I haven't got a notice that it should be dismissed, but my first court appearance, they told me to apply with CERA loan or something for assumption diversion.
Yeah.
And I just got an email saying that will be processed, or is in the process of having checks cut.
Okay, well, hang on just a second. Ms. Odom's going to try to figure out what's going on with the file, but you don't have a case today.
I'm going to have her call Sue Womack, the landlord tenant clerk.
Okay, so we're going to have you give a call to our landlord tenant clerk here at the court. Sue Womack is her name. Do you have a pen handy?
Yep.
Okay, and what is that number, Ms. Odom?
922-4488.
Okay. Thank you very much.
Yeah, okay, thank you. Good luck with your case there.
Thanks. Bye.
Right, let's go back to People versus Drew Pabuda. And that is file 211579SD. Mr. Razavy is here for Mr. Pabuda, and Mr. Chamberlain is here for the people. Mr. Razavy, this is the date for sentencing. Have you gone over the pre-sentence investigation report and assessment with your client?
Yes, we've had the chance to go over both those documents. Both those documents are factually accurate.
All right, then. So what would you like to say on behalf of Mr. Pabuda?
Well, thank you, Your Honor. You know, as you mentioned in the case before yours, this is a individual with no criminal history. He is working. He's had no issues since the incident happened in May, and he has served 2 days in jail thus far on this case. The Catholic Human Services assessment indicates that he does not have a diagnosis for a substance use disorder. There was no evidence of a pattern of problematic alcohol or drug use. The recommendation by probation is for fines and costs, and that's what we would like to see for Mr. Pabuda. As you are aware, the assessment, despite him not having a diagnosis, does recommend the alcohol highway safety class with victims impact panel. I'm not sure I've ever seen a Catholic Human Services report not recommend that. That may not be the case, but most, if not all of them that I've seen recommend that. I would not classify the alcohol highway safety class and victims impact panel as necessarily a rehabilitative program in as much as an educational program. So seeing that doesn't offend me or Mr. Pabuda in any way. Education it's a good thing, and it could apply to every one of us. But I don't think it would be necessary in this case without having a rehabilitative need. Again, him not having any form of diagnosis for a substance abuse disorder. So with that, Your Honor, I would ask that the court follow the recommendations by probation. Again, credit for the 2 days in jail, which he served, which is really a significant punishment for someone like Mr. Pabuda, who's never had any experience in the county jail or any trouble with the law, as well as the fines and costs. If the court is unable or not willing to do that because of the alcohol highway safety class recommendation, then I would ask that we keep him on discretionary testing, give him maybe 60 days to complete the alcohol highway safety class victims impact panel, and upon proof of completion, allow him off of probation. Beyond that, I do know that he would like to address the court for his statements as to his actions here.
Okay, I did have one concern, and that was that although the defendant was ordered not to use or possess alcohol or mind or mood altering substances, it says that he's been consuming alcohol and marijuana while on bond. There was discretionary testing only, so I'm going to guess that means no testing. But
that
anyhow,
does appear to be the case.
What's that?
I think you're correct, Your Honor.
Okay, so, all right, well, I guess I'll have Mr. Pabuda address that, and anything else you'd like to say, Mr. Pabuda?
I will say during my PSI, I'm not exact. I can look up her name real quick. I believe it was Amanda was her name. It was during my PSI that they said it was uncommon that I was not required to not possess or consume any alcohol. I understand that that may not have been the best decision. She also stated that it was very odd that that was not the case. However, I did not go against any orders or anything like that. But I do understand that my actions have not been, the best, and the decisions I made were not good for the people and anything like that. But I do apologize for my actions regardless.
Okay, what I took away from that is you believe your bond conditions did not prohibit you from using alcohol. Is that what you're saying?
That is correct, yes. And I'm just confirming the name here on the PSI.
Your Honor, I just checked. That's accurate. He was only given an interim bond.
Okay, then on the PSI where it says special bond conditions, discretionary testing ordered, that should be stricken. For some reason, well, it must be the action in court where the bond was set then, correct?
Yeah, I've got an interim on 5/5, and then the action in court on 5/25 that has discretionary, but it doesn't say not to consume or possess alcohol or no marijuana on there.
I would like to add, oh, I'm sorry, continue.
I just wanted to clarify that, so appreciate it, Mr. Chamberlain. Yeah, anything else you want to say, Mr. Pabuda?
I was just going to add that if that were the case, then I absolutely would not have consumed anything along the lines of alcohol or marijuana. I would really like to not, or I would be saying that I would follow the rules if the rules were set in place to not do so. I absolutely would not have partaken in those actions if that were the case.
Okay, thank you. All right then, so Mr. Chamberlain, is there anything for the people?
Yes, Your Honor. I think it would be helpful to have probation in this sense, just because we don't really know how he's doing with alcohol. I suggest a 6-month probation with the ability to, after 3 months, to see how he's doing, to let him get off early if he has no bond violations, and also if he gets his the alcohol, highway safety, and the victim impact panel complete.
Okay. All right, thank you, Mr. Chamberlain. So this is sentencing on defendant's conviction of impaired driving. The facts are the defendant was in Traverse City where he consumed more alcohol than he should have prior to driving. And he was pulled over going through a red light, turning left. And the defendant does dispute whether it was red or yellow, but I'm assuming the officer had not been consuming any alcohol, and the defendant had a 0.08 and a 0.09 on the data master, a 0.11 on the road. The defendant was not ordered to do any testing in this case. He was simply given an interim bond. And there was an assessment done that did not indicate a substance use disorder, but it does recommend the alcohol highway safety education program and the victim impact panel. And what I'll say about that is, although that is a more often than not part of the recommendation with a Catholic Human Services evaluation, I've also been informed by Catholic Human Services that they don't always recommend that. And I know there are times they don't, and that it has something to do with they see some riskiness. And that's why they recommend those things. So I do think, given the fact that the defendant hasn't been on any period where he's been asked not to use substances, and the reason we do that is we want to get a better sense, not just from what the defendant says to an assessor, which can be minimized, but also some sort of testing to show that and verify that there isn't more of a problem. Because when people use substances in violation of bond, well, it's more likely there is a problem anyhow. So the purpose of the probation, and I disagree with Mr. Ransavy's argument that the alcohol, highway safety education class and victim impact panel are not rehabilitative measures. They're being recommended by Catholic Human Services, which is a substance use disorder assessor, and they perform those types of educational classes for the purpose of assuring that the defendant has a better understanding of the effects of driving intoxicated and the effects it can have on victims. In fact, I think there's a good case to be made that those classes should be mandatory in any OWI case. I think that in itself is a good way to underscore the importance of not operating while intoxicated. But I'm not going to order that unless it's being recommended by the assessment. So this is what I'm going to do. Oh, and I do want to mention that Mr. Pabuda, to his credit, he has no prior criminal history. He is well educated. He's got some college. He's employed at Rova State, and I think he's been there 3 years is what the assessment said, and so they must like him there, and does okay otherwise, and seems to be an upstanding citizen otherwise. And I don't doubt anything he's saying about well, there was no bond condition requiring no use of alcohol or drugs, and so Mr. Pabuda, I don't doubt anything you're saying about what you were told. So what I am going to do is place the defendant on a short term of probation, 6 months, with a review at 3 months, which means if you complete all the conditions of the probation, I would consider releasing you from supervision at that time. The fine is going to be $100. Costs are $400. Crime Victims Fund $75. Judicial System fee is $50. And you'll need to repay the cost of your court-appointed attorney, which is $250. There's also a $125 arresting agency fee. I also want to note there's been mention of the last case that I just sentenced that seems to be on all fours with this case, except that in that case, the defendant was in counseling and completed an educational session as part of the assessment. And so I'm not finding that this is a whole lot different. And in that case, the defendant was also ordered to abstain from using alcohol. There were discretionary tests ordered, and apparently there were never any violations, although honestly, I don't know whether there was any testing either. The conditions of the probation are going to be as follows. You're to, let's see, no use or possession of alcohol or let's see, controlled substances, no illegal substances, obviously, no non-prescribed medications, and no mind or mood altering substances. That would include marijuana unless you have a valid medical marijuana card. You're to provide any prescriptions you do have to your probation officer so they're aware of those. I am going to order discretionary testing only although I do need to get a benchmark test today, and the purpose of that would be, we know the defendant is using marijuana, so, or was at least, and I want to make sure that if there's THC in your system, we know what the level is today, so that would not be a violation of your bond, but in the future, we'd expect to see that number going down or zero.
Mhm.
The let's see, the alcohol testing, I am going to impose 4 times random tests, and your probation officer can lower that if you're doing well. The other conditions of your probation will be that you not enter bars or casinos. I don't view Rove Vineyards as a bar. They have a tasting room, I believe. But you can possess alcohol for work purposes only. Okay, so that's not that shouldn't interfere with your work at all.
Okay.
And let's see, there's also no operating a motor vehicle with any of those substances I just described, any amount of those substances. You're not to operate a vehicle without a valid license, registration, and insurance. You're to be respectful of all court employees and care providers. Complete the alcohol highway safety education and victim impact panel. It's recommended in the report. And let's see, I think that's it. If you do have any contacts with law enforcement, you need to report those to your probation officer. And let's see, that's it for today then. Unless there's anything else for you, Mr. Rasby?
No, Drew, I'll follow up with you after we get out of court.
Okay.
And Mr. Chamberlain, anything else?
Thank you.
Okay, and Mr. Pabuda, Mr. Rasby is going to talk to you, and so I'm sure he's going to tell you need to contact the probation office so that they can go over these conditions with you in more detail and answer any questions you have, including the discretionary test that's been ordered for today, okay? All right, we're all set. Oh, if I didn't say it, there is 2 days of credit for the time served. And that's it. All right. Thank you again. Good luck, Mr. Pabuda. And hopefully I can sign a discharge from probation in 3 months here. Okay.
Okay. Thank you.
Yeah. All right. Is Robert Clark present?
Yes, he is, Your Honor. He's in my office.
Okay. So good morning, Mr. Clark and Mr. Burdett. This is file 201465 SD, and that is People versus Howard. Mr. Chamberlain is here for the people. It's the date set for a probation violation hearing. Mr. Burdett, what does your client wish to do?
Your Honor, I spoke with my client. There's only the June 2nd positive PBT is the only probation violation allegation that's kind of in dispute. My client does admit the 6/12, June 6th, the June 12th miss AM PBT. He failed to report to probation on June 9th because he missed PBT on July 4th. He has explanations for those, but the only thing that we're actually contesting is the June 2nd positive AM PBT.
Oh, you are contesting the positive then?
Yeah, just the first one. Yeah.
All right. Well, Mr. Chamberlain, given that the defendant is contesting the positive, I think we need to take some testimony on that.
I agree.
And Ms. Morton. So why don't we go ahead and deal with that then first? So let's see. Do you want to, well, Ms. Morton, could you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
All right, put your hand down. And is it true that Mr. Howard was placed on probation on January 15th of this year for the offense of operating while intoxicated? And as a condition of that probation, he was not to use or possess alcohol?
That is correct.
Is it also true that on June 2nd, the defendant tested positive according to a report that you received for alcohol?
Yes, on June 2nd, I received a report from Smart Start that he took a required AM PBT at 8:57 a.m. with a result of 0.013. And then he failed to retest at 9:04 hours. And they are told when they have a Smart Start machine that they need to continue testing as the machine requires. And if they walk away or do not retest, it will be presumed as a positive test or a positive. So he has one positive and then he failed to test.
All right. How often was Mr. Howard required to test?
Once daily in the morning.
And that's been throughout his probation?
Well, I just received him on June 1st, and that is what he's been testing since January 15th of 2021.
Okay, so apparently, according to the report, there haven't been any other positive tests during that time period, right?
No, that's incorrect. Let me look here a second.
Oh, I'm sorry. I didn't look far enough down there.
There's previous probation violations that he's been giving numerous verbal warnings for, and some of them include positive PBTs.
Yeah, you're right. Okay. And those will be the ones that are listed on the report.
That's correct.
Okay. All right. Mr. Chamberlain, do you have any additional questions for Ms. Morton?
One, Ms. Morton, when the testing occurs, can he any time, or can he test any time between 6 a.m. and 9 a.m., or is it a specific time when like a buzzer goes off?
He according to our court, he can test anytime between 6 and 9 a.m.
No other questions, thank you.
All right, Mr. Burdett, any questions for Ms. Morton?
I don't have any questions, Your Honor.
All right. Any additional evidence you'd like to present, Ms. Morton or Mr. Chamberlain?
The only thing I would like to say is that I did try to contact the defendant regarding the positive PBT, and I never got a response regarding it.
Okay. Mr. Burdett, is there anything you'd like to present in the way of evidence?
Yes, Your Honor. I'd like to call my client to the stand.
All right. So, Mr. Howard, if you could please raise your right hand. And do you swear or affirm that the testimony you're about to give will be the truth? Okay, and I need you to lean into your device a little bit, the microphone, so that I can hear you better. That was difficult to hear, but I did hear you say I will. So, okay, so go ahead, Mr. Burdett.
Yes, Mr. Howard, were you required to take a PBT test on June 2nd of 2021?
Yes.
Okay. And the allegation is that the test was 0.013. Were you drinking that day?
No.
Okay. And why would you, do you have any idea of why this would come up with such a low test on it?
I really don't have any idea. All I can remember is maybe I brushed my teeth too close to the testing date time, or rinsed my mouth. I don't know.
And was there a reason for the retest? Did you skip the retest?
Yeah, normally I just blow into the machine and then I hide it back under some towels. And I never really look at it. It's usually always just fine. So I just blow and then it clicks and then it keeps beeping and then I just hide it under some towels so I can't hear it anymore. And I keep it in the garage.
Okay. And why do you keep it in the garage?
Because it'll wake me up in the morning and beeping.
Okay. And did you receive a call or anything to call the probation department regarding that? The positive, you can recall?
I don't think I did. I received a couple of calls from Jana, and I tried calling her back, and she never called me back.
I don't have any further questions, Your Honor.
All right. Mr. Chamberlain, do you have questions for the defendant?
No.
All right. Ms. Morton, any questions?
No, Your Honor.
All right. Well, I have a couple questions here. Sir, you were told when you started testing that you're supposed to wait, not put anything in your mouth for 15 minutes before you test. Isn't that correct?
Yes.
All right. But you're saying it was brushing your teeth or rinsing your mouth. So you wouldn't have done that 15 minutes, within 15 minutes prior to the test because you were told not to do that, right?
Yes.
And you also were told that you need to retest. And if you don't, it's presumed that it must be a good positive there if you don't retest. Is that correct?
Well, I didn't know I had to retest because I just blew into it and I put it away. And it constantly
Weren't you told you're supposed to do the retest, and if you don't, then you're subject to, the assumption that another test wouldn't be any help because you decided not to test?
Well, no, I didn't know I had to retest because I tested and I put it away. So I did not know I was supposed to retest.
And I see where you've retested on January 13th. There's a .021, then a .017, and a .013. You retested on January 21st. There's an 057 and 046. You retested on February 8th. There's 3 different readings. You retested, let's see, and you received verbal warnings on those dates. So, and then I could look at the ones in March as well. On March 14th, 2 tests, another verbal warning. So you know how to retest, and you know when there's a positive test, you got to take another one.
Well,
am I missing something?
I did not do it.
Okay.
Like I said,
Mr. Burdett, any further questions based on my questioning?
Yes, Your Honor. Mr. Howard, when you did that test, you indicated you just put it away after you did the first test.
Yes, because normally everything's just fine. I don't look at it and I just tuck it away again and don't read it.
Okay. So were you aware it was a positive test?
No.
And if it was a positive test, you would have retested?
Yes.
I don't need further questions, Your Honor.
All right, Ms. Morton or Mr. Chamberlain, any follow-up questions?
I have one.
Go ahead.
Mr. Howard, looking back at the notes with your old PO, Christy Helmrich, you never admitted to drinking on those other positive PBTs in January and March, correct?
Correct.
And you told her, the last notes I have on March 15th, you told her you have not drank since this incident happened. Is that correct?
I can't quite understand you.
You told Ms. Helmrich on March 15th, after all of these positive PBTs listed on this form, you never admitted to those positive PBTs. You said you have not drank since this incident that caused your arrest, correct?
Correct.
And you still say to this date that you have not drank alcohol since your OWI arrest?
Maybe a little, but not a lot.
So you have drank since your arrest?
Very little.
I have no further questions.
Okay, so I am gonna find that the defendant did consume alcohol on, let me get the violation up here again. All right, on June 2nd. And I'm gonna just say, Mr. Howard.
Maybe I can get over there like at 1 at your house.
Okay, Mr. Hickman, I think I got you that I hear, or maybe it's Mr. Chamberlain's office.
But I'll move it anyway.
Thanks.
Oh, okay, thank you. I think it was Mr. Chamberlain, so. Okay, so Mr. Howard, you know, what ridiculous testimony. You're just lying, okay? And I mean, your history of blowing positive on these tests, and then you want to say you brushed your teeth or you rinsed your mouth. It's really insulting to sit here and just have someone bold-faced lie to me. But you know what? You're just hurting yourself because you can't get help for an alcohol problem. I mean, you're waking up with, you know, in one case in 04 in the morning, and that's waiting until the last minute to test, just before 9 o'clock. So you're getting sloshed at night and then trying to sober up in time for the test. And it's apparent to everybody on this call. It's apparent you're just lying. So anyhow, you've been given verbal warnings in the past. Frankly, I don't even care about the other violations. I say that not just to embarrass you or humiliate you, but, you know, you just sound so ridiculous to everybody on this call. And all you're doing is fooling yourself. And I'm sure, that's what other people around you in your life are hearing too. And you're just not doing yourself any good. People can't help you. Counselors can't help you, et cetera, if you're not honest with them. So I think the recommendations in this case are appropriate. I should give you an additional 5 days just because of the perjury.
Your Honor,
But yeah.
may I make a suggestion?
Yeah.
I agree with everything you said, especially that he's testing at the last minute in order to get through these violations. I also have additional information from the family that he is essentially always drunk. He knows when to get through his these things. This is something that appears to be happening every single day from the information I've received from the family. I actually suggest either 90 days in jail or 30 days in rehab, because that's what the family wants, is him to get help. And I think that's the only way that's going to happen. Thanks.
Your Honor, if I could say something
Yeah,
on Mr.
go ahead.
Howard's behalf.
Yeah, go ahead, Mr. Burdett.
My client has 2 weeks ago went to Munson Behavioral Health.
Try.
He is going to Munson Behavioral Health?
Yes, Your Honor. And his doctor prescribed him what's called naltrexone, Naltrexone, which is a drug that lessens the desire for alcohol. So he's addressing the problems that he has, and looking at the recommendation of the 5 additional days in jail. I think when you look at the email and the requests and the facts of this case, that possibly more of a increasing testing, like maybe 2 times a day instead of 1 a.m., maybe 1 a.m. and 1 p.m. Hold the 5 days in abeyance. Have him continue to comply with Munson Behavioral Health and take the naltrexone that he's prescribed. And if the probation department wants another assessment by Catholic Human Services, my client's willing to do that as well. But I think in this case, possibly just an increased testing and an increased monitoring, and the proof that he's taken the naltrexone that is prescribed to him from his doctor from Munson Behavioral Health would go a long way toward keeping Mr. Howard within the conditions of his probation. I spoke with him about the 5 additional days in jail. He does not wish to go to jail, Your Honor. But I think if we hold that in abeyance, that if he does violate his probation again, that the court could just sentence him just sua sponte right to jail for 5 days. Because he has made some progress, and he is making some positive steps. But I think that'd be a better resolution, Your Honor, for Mr. Howard.
Okay, thank you, Mr. Burdett.
Your Honor, can I just?
Yes, go ahead, Ms. Morton.
I just want to briefly say I agree with Mr. Chamberlain with his recommendations of what he just said, but I would also ask, if he does get jailed, that he not the increased testing of twice daily, but because of the letter from his wife, a cam device be put on his ankle. That's all.
Okay, well, when's he supposed to begin the naltrexone?
I'm on it right now.
He's on it right now, Your Honor, and his wife is here in my office with me, and she would like to address the court if she could.
Okay. What's your name, ma'am?
Renee.
Okay, good morning. Ms. Howard, and what would you like to say?
I just wanted to tell you that I did write the letter, and myself and our kids, we want Rob healthy. We don't want him in jail. We just would love the court to get to have him get some rehab so that he can get better.
Okay. Given his alcoholism, do you make an effort to hide the car keys? I'd have them locked up, because I'll tell you what, it's tragic enough having an alcohol problem. You know, he's here because he was drinking and driving. And yeah. I'm sure everyone would feel a lot worse here if someone got injured, and including your husband, if he were to get injured. So that would be a recommendation I would make if I were living with someone that is just intoxicated all the time. So, well, I appreciate what you're saying, and that's really the goal of everyone here. Is we just want to see Mr. Howard address the alcohol problem, and it's not an easy thing. I'm glad he's trying medication to see if that will help. And you know, the jail component of this, which was being requested, you know, when there's just nothing else we can do, you know, that's where we go. But I think given that the defendant is now taking the naltrexone, I want to give him another opportunity. He probably needs to be in at least a 30-day treatment program. But I'm not going to try to make that happen today. He is seeing Munson Behavioral Health, although if he's this dishonest with me today, he's probably being dishonest with them. But the thing is, they can see through him also when they know about these violations. So he's to provide a copy of the probation violation report to them, so they're aware of what's actually going on. He's to continue that counseling and follow any additional recommendations. He's to be on a CAM device, and that is for public safety. But I am going to impose an additional 5 days in jail as a result of multiple violations. He's received warnings for all of these others, but I want Mr. Howard to understand that even though it's probably not going to solve any problems, at some point, you know, that's what you're looking at, is just doing the whole 93 days. If you don't try to address this problem head on. And it's really sad because it's affecting your family, and they obviously care a lot about you. And anyhow, so that's what we're going to do. Let's see, what was the other recommendation here? Oh, and to complete the new intake. Now it says Catholic Human Services, but he's seeing Munson Behavioral Health. So either would be acceptable. Do you agree with that, Ms. Morton?
Well, I'm a little confused. It sounded to me like he was just getting medication provided. I don't have anything that he's actually had an intake in counseling, like outpatient counseling there. So I'm
okay. All right. So I will allow the intake at either location. If he's getting medication through MBH, maybe that makes more sense to move his counseling over there. But either way, disclose all the violations by providing them with the actual violation report, and my findings that all of these violations occurred, and then you do need to report to the jail today by 5 p.m. You're going to miss out on your weekend here, so Let's see, anything else for you, Mr. Burdett?
No, Your Honor, except I spoke with my client and he is doing counseling through months in behavioral health in addition to being prescribed the Trexone.
Okay, well, he's doing the right things, but again, if you're not honest with them, it's like going to the doctor and not telling them what's really wrong, okay? So,
Your
all
Honor,
right, well,
just,
yeah,
can we just, I know you ordered the CAM device. Can we just make sure it's on the dispo that he can't be released from jail without the CAM device?
okay, good point. So the defendant is not to be released from the jail unless he has a CAM device, and that assures me I'm doing everything I can to protect the public in this case from the defendant getting in a car and being intoxicated. So, all right. So, thank you, Ms. Morton, and we're all set for today. And believe it or not, Mr. Howard, we all just want to see you get better and be healthy, okay?
I know that.
All right, so feel free to sign off at this time. We'll go on to People versus Cassandra Bermudez. And I don't think I've seen Ms. Bermudez here this morning. Are you there, ma'am?
Your Honor, last I knew she was in either Antrim or Grand Traverse jail.
All right. Ms. Odom, do you have a way to check on that right now?
I do on the Traverse City Jail. I can check.
Okay.
Let's see.
I believe
We'll go
it's
on
for,
then.
is this for her sentencing? I believe I did a PSI on her and she was in Ottawa County.
Oh, yeah, I did see that in the report there. So she may be in Ottawa County. Well, how about we just, since everyone seems to agree she's probably in jail, let's reset this sentencing and we'll figure out where she's at. If she's still going to be in Ottawa, we'll need to do a writ. And we'll schedule that out to our next Leelanau County day. Let's see, she's representing herself, so no attorney required. Did we have any victim here today? Let's see. Mr. Bermudez? No. Okay, then we're all set on that case. Let's go on to People versus Asher Hilborn. Is Ms. Hilborn present?
Yeah. What?
I'm sorry, I said Ms. and I should know Asher is a boy's name. I'm sorry about that, especially when the middle name is Joel. Let's see. So, Mr. Hilborn, do you have an attorney for this case?
Yes, Your Honor. For
there
some
he is.
reason, I'm not listed on the online docket as counsel, but I am Mr. Hilborn's counsel.
I see. Okay, thank you. Okay, so this is the date for a plea, and is that what your client wishes to do, Mr. Travis?
It is, Your Honor. Your Honor, my understanding of the plea offer is that if Mr. Hilborn pleads to an operating while impaired and agrees to forfeit the firearm involved in this case, that the prosecutor will dismiss the operating while intoxicated and the CCW between 0.08 and 0.1.
All right, Mr. Chamberlain, is that an accurate statement of the plea agreement?
Yes, Your Honor, thank you.
All right, so most importantly, Mr. Hilborn, is that your understanding of the plea agreement? You're going to plead to a reduced charge of operating while visibly impaired, and also the carrying a concealed weapon would be dismissed along with the OWI.
Yes.
All right, and do you understand that by pleading guilty, you will have a conviction for operating while visibly impaired, and that carries a maximum penalty of up to 93 days in jail?
Yes.
Has Mr. Travis answered all of your questions to your satisfaction?
Yes.
Have you been promised anything else that hasn't been disclosed on the record this morning to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
I have not, no.
Right. I do need to go over your trial rights with you before I'm able to accept a plea and make sure you understand all those. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial. Do you understand that?
Yes.
You also have the right to have the witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights? Was that a yes?
Yes.
Okay. And you also have the right to testify at a trial, or if you choose, to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. And any appeal would be by leave, not by right, meaning it would be up to the appeals court whether to even hear your case. Do you understand that right?
Yes.
And do you understand that by pleading guilty, you're giving up all those rights you would have if you went to trial?
Yes.
All right. So is it true that on May 15th, you were driving your car on East Traverse Highway in Solon County, or Solon Township, Leelanau County, when you were pulled over by a police officer?
Yeah. Yes.
Yeah. All right. Is it true you'd been consuming alcohol prior to driving?
Yes.
Was there a breath test that was given? Do you know if there was a breath test given, sir?
Yes, there was.
And that was in 09, is that correct?
Yes.
And would you agree that because of consuming alcohol, your ability to operate a motor vehicle was visibly impaired, meaning another driver might have noticed that alcohol was having an effect on your driving?
Yes.
Okay. Then to the charge of operating while visibly impaired, how do you plead?
Guilty.
All right, I'll accept your plea. I find it's voluntary, accurate, and understanding. The original charges will be dismissed at the time of your sentencing. And Ms. Odom, we want to work with Mr. Travis on a date.
Sure. How about July 30th at 9:15?
Yes,
Thank you.
thank you.
Okay. Let's see. So we'll be back here on that date. Prior to that time, I do need to get an alcohol assessment and a pre-sentence investigation report. You'll need to contact our probation office, and I'll give you a phone number for that, sir. So please write this down and call them between 1 and 4 p.m. this afternoon. The number is 231-922-6899.
Okay.
All right, we're all set for this morning then, and we'll see you back for sentencing.
Perfect. Good.
Yeah, you can feel free to sign off at this time if you like, Mr. Hilborn.
Thank you.
And thank you, Mr. Travis. So let's go on to People versus Jennifer Fifield. And that is file 1569SD of 2021. Mr. Hickman is here on behalf of Ms. Fifield, Mr. Chamberlain for the people. And this is the date for a final conference. So has a final conference offer been made, Mr. Chamberlain?
Your Honor, my notes indicate that sobriety court has been offered.
All right, Mr. Hickman, does your client wish to take advantage of that, or is this going to go to trial? You're muted, Mr. Hickman.
Okay, that's better. I believe my client will want to do that. However, in the meantime, she's picked up another one for which she was just arraigned the other day. And
What
I was
county?
in Leelanau County.
Okay.
Grand Traverse County.
Oh, Grand Traverse County. I'm sorry. It was in Grand Traverse County.
Oh.
Okay. I wondered if we might set this for another final conference so that we could potentially resolve both matters.
Okay, well, that sounds like a good idea. There's no sense doing sobriety court if the Grand Traverse prosecutor's not going to go along with that. So we'll go ahead and reset this for another final conference on our next Leelanau County Day. And that is on, did you say July 30th, Ms. Odom?
Oh, we can do it that day, yeah.
Okay, so we'll do it on July 30th. By that time, I'm assuming there'll be a charge of OWY third and the Grand Traverse County case.
It's a second.
It's a second.
It's got pre-trial.
It's a second because there's no second conviction yet in this case. So,
That's what.
Right.
Okay.
all right.
Be careful.
Pre-trial in that case was held on July 13th, but I don't.
All right. Well, I'm sure Mr. Chamberlain's going to reach out to Grand Traverse County and get this figured out.
Yeah.
So,
okay.
All right. So we'll see you back on that date then. And given that situation, however, I do want to address bond. How often is the defendant testing?
I believe she's on, I think she has an anklet.
I do.
You do. Okay. All right. Well, it sounds like that was a result of the more recent arrest. And so you're to comply with all conditions of your latest bond. And so we'll redo the bond form in this case to just make sure that those two are consistent. Okay.
Yes, sir.
Thank you, Your Honor.
All right, thank you, and we'll see you back on the 30th. Feel free to sign off, Ms. Fifield, if you like. Let's see, the next case is People versus Christopher Harper. Is Mr. Harper present?
Yes, Your Honor.
Okay, good morning.
Good morning.
And Mr. Travis is here on behalf of Mr. Harper, Mr. Chamberlain for the people. This is the date set for a probation violation hearing. Mr. Travis, what does your client wish to do?
Your Honor, I guess relative to this, he would plead guilty to violating probation, but the second violation that he failed to attend grief counseling, I don't know if, I think it got to the court. It was being emailed around this morning. That would be more maybe appropriately that he didn't provide documentation of grief counseling, but he has attended the grief counseling. And he has also been attending the early recovery group. He just hasn't completed it. But to the fact that he violated probation, he would plead guilty. There's just maybe some caveats.
Okay, so we'll certainly listen to whatever explanations there are before making any decisions today. So, Mr. Harper, is that correct? You want to plead guilty to the probation violations with an explanation?
Yes, Your Honor.
All right, and let's see. Okay, so you understand that by pleading guilty to a probation violation, the worst that could happen is your probation could be revoked and you could be sentenced to up to 1 year in jail.
Yes, Your Honor.
Okay, that's obviously not what's being recommended. It is being recommended your probation be revoked in 60 days in jail. But what you should know is I don't always follow those recommendations. Do you understand that?
Yeah.
All right. And you haven't been threatened, forced, or coerced, or pressured in any way, or promised anything to get you to plead guilty to the violations today, have you?
No, Your Honor.
Okay. All right, then. Is it true you were placed on probation on December looks like 12th of 2019, and that was for an OWI second case?
Yes, Your Honor.
And as a condition of that, you were to complete your early recovery group at ATS and provide verification of that to your probation officer. And although you completed the early recovery group, according to your attorney, you didn't do it when you were supposed to, or at least you didn't let your probation officer know that you had done that. Is that true?
Yes, yes, Your Honor.
Your Honor, actually, that was the grief counseling, not the early recovery.
Okay. So you haven't attended the early recovery group, or you haven't gone to all the sessions?
All the sessions. I believe it's 12 weeks, and yesterday made it class 5 or 6.
Okay. Is it also true you were ordered to attend grief counseling? And now, although you completed that, according to your attorney, you didn't let your probation officer know in a timely fashion?
Yes, Your Honor. Or my probation officer switched, and I was I guess not immature, just I didn't know I was going to have 3 probation officers by now, and I should have definitely saved my files of what I've sent to my last probation officers instead of just it's sent, it's done, she has it, that's that. I always have to reflect on myself to remember it's probation it's on you. It's on you. It's not It's not the court or probation officer's fault. You need to provide your paperwork and that's on me. Still, I guess, not fully matured.
Okay. And then the other violation was for failing to make a truthful report to probation on June 11th. Can you tell me what happened there?
Yes, Your Honor, a very ignorant decision. I'm sorry, Mrs. Morton. I don't lie. I don't lie. It was a very impulsive, stupid decision that I regretted instantly and emailed Mrs. Morton instantly. But I still get a liar will look like a liar. She asked me I've been in a dark cloud, very depressed and suicidal. And she asked me, did I see my counselor or did I go to my follow-up? I believe that day or the day before. And I told her, I choked up and told her yes. And she's spoken to Mrs. Merriman right before me, and I was caught in that lie, but that's what the lie was from. She just asked me if I went to my follow-up, and I said yes, like an idiot. And I instantly regretted it, but I understand if you don't accept my apology. I do. I've just been real messed up in the head, Your Honor. And I just like the opportunity to get better. And right after this, I'll be going, if you let me have an opportunity, I'll be going to partial hospitalization at Munson. Just waiting on my grandmother and aunt to get home, and we'll be headed there if I am allowed to.
Okay. Where are you going for the hospitalization? Is that Munson?
Yes, Your Honor.
And you're set to go there right after this?
Yes, Your Honor.
All right. Well, I do accept your apology, sir. And
I'm sorry, Mrs. Martin, as well. Let you down.
Okay. Appreciate that. All right. Well, as far as the violations go, how do you plead then?
Guilty, Your Honor.
All right. I'll accept those pleas and find it's voluntary and understanding. So, all right. Well, Mr. Travis, what would you like to say then on behalf of Mr. Harper?
Thank you, Your Honor. Your Honor, there's two things I tried to get out and communicate. And initially, I sent them to Ms. Webster, not Ms. Odom. So they are not only being sent this morning, but initially didn't get sent in the right spot. But one's a letter from Shaquita Brand, or an email from Shaquita Brand about grief counseling, stating that she met with him on several occasions, actually talking about how he's kept in contact with her through COVID and about his sobriety, and basically that she feels that he's done quite well and asking the court not to give him 60 days in jail. The other is from the counselor. It's a letter stating basically that after speaking with Mr. Harper yesterday for his regular counseling appointment, she suggested he not turn himself in, but go to D6 or to Munson Behavioral Health to get evaluated and potentially go in. She also suggested if he didn't want to do that, to contact for outpatient treatment. Mr. Harper has followed her suggestions and contacted them, and it is my understanding that he can go there right after today, and that's really what she feels he should do. Relative to the violations, Mr. Harper, as he acknowledged, he messed up, and probably the most concerning issue is the fact that he did lie to Mrs. Morton. A lot of the rest of this is a failure of him to keep track of things and do things as he should have, but he has done quite well on the most important factor here on a drunk driving second, at least I believe, is the not drinking and the maintaining sobriety, and that was initially a problem, and he's had a lot going on in his personal life and with his family in recent history, and he's been working on that. So even if the court feels jail time is appropriate, I don't know that 60 days for basically not taking care of his duties is what would need to result here. We would ask the court to keep him on probation. He's, like he indicated, he's probably only got about 6 or more sessions left to complete the counseling. He probably is going to continue with the counseling, just like it's kind of indicated from Mrs. Brandt that he's continued interacting with her even after their grief counseling as a support. He's been employed, I think, almost through this entire case. He was working at casino as a cashier. He's now changed jobs and is working at Sam's Club. I know he's very concerned about maintaining employment. And as I said, he's done pretty well with the sobriety portion. He's just had some other issues, and that's, I would ask the court to allow him to turn himself into the hospital. Thank you.
All right, I do see
I've been
Ms.
clean, Your
Brand
Honor.
is.
I'm sorry.
Okay,
I'm sorry.
thank you. I see Ms. Brand is here, and I would like to hear from you, Ms. Brand, if there's anything else you'd like to add beyond the letter that you provided to the court.
Good morning, Your Honor. Hi. So, Chris immediately reached out to me once he got the third probation officer, within regards of documentation. And we went over, the ways of documenting and making sure that he keeps copies to himself. With the depression piece and things of that nature, he has been in contact with me more recently with the depression. And he did state to me today that he was going to turn himself into the hospital. So I had spoken to him right before court started about the decision of going and, being checked into the hospital to help with this piece that he's having a hard time with, and I, personally myself, the 60 days, I don't see where that's warranted. I understand he has to make up for the fact that he violated, but with him having a job, there's a lot of things I've seen growth in him during this period of his life that, having a setback as far as 60 days that he'll lose his job, he'll lose his place. So there's a lot of things at stake that will actually send him back into a further spiral. And so agreeing with his counselor is putting him, having him check himself into the hospital so he can kind of get over this hump of what he's going through. I would see that be more beneficial than the latter of the 60 days.
All right. Of course, the concern I always have is that the hospitalization is meant to be an attempt not to do the jail time. And you can see my perspective, I'm sure.
Yes.
How long do you anticipate he would be hospitalized?
I couldn't answer that. That would be up to his counselor, how long she would feel that he'd need to be hospitalized.
Okay. And all right. Well, I appreciate you being here and providing additional information to the court. Mr. Chamberlain, anything you'd like to add?
Your Honor, I try to be fair in these. Frankly, I think the previous person we had deserved 90 days, and I feel that his actions were much more egregious than Mr. Harper's. I think probation would be helpful for Mr. Harper. I've spoken to Ms. Brand multiple times before, not necessarily on this case, but I also trust her judgment. I think hospitalization is appropriate. And what I would suggest is do hospitalization. As soon as he's done with hospitalization, he has to do either an inpatient grief counseling or inpatient counseling of some sort for mental health for a minute. And that must be started within 30 days following hospitalization. And that could, if an intensive outpatient type of mental health treatment is available, I'm not sure of all the different resources that are available, but he needs two things. He needs hospitalization right now, and he needs probation that will also include some extremely intensive counseling likely inpatient treatment to get through his issues. Thank you, Your Honor.
All right, Ms. Morton, is there anything you'd like to add?
Yes, Your Honor. I'd just like to say again, I received Mr. Harper's case on June 1st. I accept his apology. It's very hard to come into a new case and have someone lie to you off the bat. But I don't think that this was an impulsive lie. Going back to the notes, he's been telling his probation officer since August of last year that he's been attending early recovery at ATS. He said August 27th, and then he said again in March, April, May, he's been attending. I can't say why they haven't checked up on him. I had no proof of it. That's why I followed through to get information and to get clarification. So I don't think it was an impulsive lie. He emailed it to me on his report day that he was attending. I contacted ATS, confirmed that he was not, called Mr. Harper to give him a chance to be honest. He lied. And eventually when I told him I was confirmed that he wasn't attending, he finally told the truth. So it's really hard to work with someone on probation when you don't trust them and they have that history. So with that said, he did say that he attended grief counseling, but did not provide us any proof. And I know Mr. Trevis said he sent it in. I don't have a copy of that as of right this second. I'm not saying that it's not there, but I don't have it. And the situation, the reason I recommended 60 days was because this is not just a retail fraud, this is an OWI second. And the most important part of probation is this rehabilitation of counseling, and he hasn't been attending it. So that was the reason why the 60 days were recommended and the revoke of probation, because it's really hard to trust someone after they lied to you about something serious. So I agree that he might need hospitalization. I'm not sure if that's D6, if that's what he said. But I guess that's all I wanted to share today.
One thing you weren't aware of when you prepared your report anyway is that he's completed the grief counseling that was the initial grief counseling anyway that was requested by the court. And I believe Mr. Harper said he has now provided those records to you. Is that true?
I have not gotten the records.
So
Your Honor,
you
what-
still don't have. Go ahead, Mr. Travis.
I had sent in an email from Ms. Brand indicating that he had went to grief counseling and discussing other matters, not like a log sheet or anything of that nature, just that where she had discussed that they had attended one-on-one grief counseling. So it's not I don't know if there was a form he was supposed to turn in or not. And if there is, I did not send that in. I just sent the email that Mrs. Brand had sent earlier, which also indicated that he had attended grief counseling.
I never received a verification sheet, Your Honor, for specifically grief counseling.
Okay, Ms. Brand, how often have you been seeing him? It wasn't clear to me from your letter.
Okay. Oh, hello, Your
Go
Honor.
ahead.
Okay, so with Harper, it was at least twice out of the week. This started roughly after he got on probation from December to January. And then we met several times after, just for him, basically just for a reach out when he was hitting his lows, when he was getting frustrated. And that's kept on. And then once the pandemic and stuff hit, once the pandemic actually hit, he would do phone-ins with me. And that was probably maybe once or twice a week or once. And it actually was sparingly, sometimes it tapered one to two times a week, and then would go into like a monthly where he just call and check in. He let me know where he was within his sobriety, that he was staying sober. So there was no official log. This is something that he did on his own accord prior to with the court saying that he needed to, meet with somebody for grief and loss.
And as far as meeting as much as you think, well, as much as you recommended that he meet with you, you feel that he's done that?
Yes.
All right. Okay, so this is what I want to say. Ms. Morton is right that this is a serious offense. The drunk driving second, where the defendant was traveling with a .1516, about double the legal limit, at 88 miles per hour as he neared the village of Sutton's Bay. So that sounds like a pretty dangerous situation to me.
Killed
You
someone.
know, I think
Could've
of
killed
people
someone.
I think of people on bikes and kids running out in the street and pedestrians crossing. And so I appreciate you saying that, Mr. Harper, because it is a serious situation. You've got a prior history that includes an alcohol offense. And so it is a serious case. And that's why you're here in front of the court, because of the danger that that situation presented. I also agree with Ms. Morton that it is difficult to work with someone who just isn't telling the truth about things. And at least with the early recovery program, it's difficult to understand why you felt it necessary to make that up. But I do understand that this defendant has some severe emotional problems. He's been dealing with that through his grief counselor, Ms. Brand. And I guess this is the thing I like to tell probationers at the beginning that, you know, we're all here to help you. We want to see you be healthy and get better, but we can't do that when you aren't honest with us. And it's the same with Ms. Brand or any counselor. You got to tell them what the problem is or they can't help you. If you don't tell the doctor what's hurting, then you don't, the doctor doesn't know how to help you. I have to believe it was out of fear for repercussions like today that you were not honest with Ms. Morton or your other probation officers about the early recovery program. And it's always better if there's a problem, if your probation officer knows about it. And I think if Ms. Morton had been told right up front, you know, I haven't done it and this is why, and I'm sorry, she would have had a different attitude about today's hearing. And I certainly agree with her frustration, okay? At the same time, Ms. Brand has been working with the defendant closely for a long time here, and the prosecutor's been keeping abreast of the situation. Just based on Mr. Harper's presentation today, it's clear to me he has some serious emotional issues going on. And so I want to do what I think is best for public safety and for Mr. Harper. And so I am going to continue the probation. I'm going to follow Mr. Chamberlain's recommendation, which I think is consistent with what Ms. Brand is recommending as well. And that will be that the defendant is to go to the hospital after this hearing. Once he's released from hospitalization, he's to complete another 30-day of mental health, intense mental health counseling, either intensive outpatient or better yet, an inpatient program, because it sounds like that's what's called for. And that needs to be started within the 30 days of release. It may take some time to get that set up. The defendant is to continue with the early education or his substance use disorder counseling and not miss any sessions unless there's an excused absence. That means if your grief counseling, which I think needs to come first, If that interferes with your other counseling schedule, then you need to let Ms. Morton know right away. And she's not going to hold that against you as long as you're telling her that there's a valid excuse and you give her proof that there is another counseling session or you're in an inpatient program, okay?
Yes, sir.
All right, so let's see. Is there anything else, Mr. Chamberlain or Ms. Morton, you would recommend?
Your Honor, I would hold 30 days in abeyance. If after the 30 days, if he doesn't have a really good excuse for not being in treatment, then he immediately has 30 days in jail. So there's both a carrot and a stick here.
All right, well, I'll do that with the 30 days. So, and that means if you don't follow these recommendations, there's still the full year that's available to me if there are violations. I'm not saying that that's what I would do. It's just I don't want to tie my hands there either. Ms. Morton, any other recommendations you would make given my ruling?
I guess to make it easier to follow, I would ask that he have to provide proof of hospitalization today, have it faxed to the courts, and also, if possible, before he's released, what his next step is instead of getting out. And then he has to figure out that they work that out in counseling. So there's a plan when he gets out.
Okay, so and you're talking about a plan he would put together so that you know exactly what he intends to do next.
That I would hope that when he's in hospitalization, that they come up with where he's going to go, and that they've already made calls and set it up.
I see. Okay, so Mr. Harper, you understand that you're to provide a faxed copy of your admission paperwork today to Miss Morton, okay? So once you're admitted to the hospital, you need to figure out how to get that to them. And what's that?
I said yes, Your Honor.
Oh, okay. And then upon discharge, you need to provide the discharge paperwork to Miss Morton. She's gonna want to see that so she knows what the next plan is, okay?
Yes, sir.
Okay. All right.
Yeah.
If you don't follow that instruction, you know what's going to happen. Okay.
Yep,
30
most
days in jail.
definitely.
Okay. All right. So again, I want to thank Ms. Brand for being here and providing additional information. And thank you, Mr. Travis.
Your Honor,
and,
can I interject?
yeah. Go ahead.
I just, I wish there was an ability for him to go do a 30-day inpatient mental health, but that's I think an impossibility given what's available.
That's why I also added their intensive outpatient would suffice. But I did say I thought an inpatient program would probably be better, but I agree it's probably not an easy thing to do.
So, and as to Mrs. Morton indicated, he'll most likely, if he cooperates in it, and they will create a plan for him. And I would ask the court to consider that ordering that he must comply with that plan and whatever they recommend, because it might not be as like with the substance abuse, sometimes it's daily things. A lot of times, having done a lot of MI work in the probate court, it's often, weekly, or, maybe meet with a psychologist, maybe meet with a counselor, but it's generally not like an everyday type of thing that they have him do. So I just don't want it to be a situation where he's got a court order that says he needs to do this, but no services that will match up with that. That's my only concern.
All right. Well, I'm going to rely on the hospital to you know, they probably know best what services are available and what's realistic. And I agree, even with our intensive outpatient drug court program, we're talking about usually counseling once a week, not daily.
Okay.
So, so that's kind of what I would expect, but I'm gonna order, I appreciate that. I'm gonna order that you follow whatever the recommendations of the hospital plan is, okay?
Yes, sir.
All right. So I think we're all set for today. And again, I appreciate everyone's attention to detail in this case that presents some complicated issues, okay? We're all set for today. Feel free to sign off and good luck with the mental health care. Okay, Mr. Harper.
Thank you, Your Honor, and sorry, Mrs. Morton. You guys enjoy the rest of your day.
Thank you.
Thank you.
All right, let's go on to Ms. Odom. Do you need a break?
I'm okay.
You're okay.
If you
All
are, it's up to you.
Yeah, I'll do one more here. So People versus Tiffany Adams. Is Tiffany Adams present?
Yes, Your Honor.
Okay, good morning, Ms. Adams.
Good morning.
And Mr. Becker is also present. And this is the date set for a plea in file 201340SD. Mr. Chamberlain is here for the people. So Mr. Becker, is your client wanting to plead guilty today?
Yes, Your Honor.
And is there any plea offer?
No, Your Honor. Well, there's the prosecutor and I are in agreement, talking with Mr. Hubble, that we'd both ask the court to consider no probation at sentencing, as she's towed the line for over a year now.
Okay, Mr. Chamberlain, is that correct?
I do see that in the notes, Your Honor.
Okay, so you're not looking for any probation, just fines and costs, and that's because of the extended period on bond?
That is correct, Your Honor. It looks like this case started in June of last year.
Okay. All right, so let's see, Ms. Adams, is that your understanding of the plea agreement as well?
Yes.
All right, has anything else been promised to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
District Court, Ms. Noreen. Good, Jen, what's happening over there?
Noreen, you're gonna want to mute yourself. We can hear you on the phone there. Okay, I think she must be
Thank
muted
you.
now.
I don't know how it got
Yep.
unmuted. Thank you.
Okay, thanks. All right, so I want to explain this to you. By pleading guilty, you will have a conviction for operating while intoxicated, and that carries a maximum penalty of up to 93 days in jail. Do you understand that?
Yes.
Okay, what I want to explain is the prosecutor has agreed not to object to a fines and costs only sentence with no probation. Now, the court is not bound by that, but I typically do listen to the prosecutor. If they're not looking for probation or jail time, I would typically go along with that, but that's not always the case. Do you understand that?
Yes.
Okay. And I'm assuming that the reason for that is the long probation where you've tested negative and There haven't been any problems with the bond conditions. So, but if after reviewing the whole case, I feel differently, you understand that probation and or possibly jail time are, those are options.
Yes.
Okay. All right. I do need to go over your trial rights with you. Make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt. And you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal from your conviction or sentence would be by leave, not by right, meaning it would be up to the appeals court whether to even hear your case. Do you understand that?
Yes.
So knowing all those trial rights you'll be giving up to plead guilty, is that what you want to do?
Yes.
All right then, is it true that on June 14th of 2020, you were driving your car on Schaumburg Road in Centerville Township and Leelanau County when you were either involved in an accident or pulled over by police?
Yes.
Okay, and which was it? Were you pulled over by the police?
No. I had scraped the stop sign and called a tow truck, and then the tow truck had called the police.
I see. Okay. So had you been consuming alcohol prior to driving?
Yes.
And there was a data master test that resulted in a 0.16, about double the legal limit. Is that consistent with how much you had to drink at least on that one occasion?
Yes.
All right. And would you also agree that due to the consumption of alcohol, your ability to operate a motor vehicle was substantially affected?
Yes.
All right, then. Then to the charge of operating while intoxicated, how do you plead?
Guilty.
All right, I will accept your plea. I find it's voluntary, accurate, and understanding. Mr. Becker, do we have a substance use assessment?
We are obtaining that on July 20th, Your Honor, next Tuesday.
Okay.
We couldn't get it done before.
Okay, so we will need to set this out then, despite the recommendation from the prosecutor. And I would like to get a pre-sentence investigation report as well. So you'll need to contact our probation office at 922-6899, area code 231. And please call them between 1 and 4 p.m. this afternoon, and they'll interview you about what happened, okay?
Yes.
All right. I'm also going to require the substance use assessment that you're already obtaining, and we'll be back here on July 30th if that works for you, Mr. Becker.
I'm sorry, Your Honor, I have a jury trial that day up in Petoskey.
Okay.
Could we do a plea or a sentencing from Traverse at some point around there?
That would be fine, so long as the prosecutor can have someone available to be there as well.
Zoom makes it easy, Your Honor.
What's that?
I said Zoom makes it easy, so I have no issue with that.
Okay. All right, so Ms. Odom, you want to pick a date in Grand Traverse County for that around the 30th?
Sure. July 29th at 9:15.
That would be wonderful, Your Honor.
Okay, perfect. So we'll be back on that date and for sentencing. And is there anything else we need to take up before we let Miss Adams go?
There's a request that we have, Your Honor. Could the court send kind of Tiffany is applying for and obtaining substitute teaching permits consistent with her college education. She teaches special ed. Because of the drunk driving, she needs a statement to the group that she's basically been charged with drunk driving. She's entered a plea and pens on sentencing. And I think that's all that they need.
Well, I think the disposition from today's hearing might cover all that. So we'll make sure you get a copy of the court's disposition. And if there's anything else they need, I'll make sure that we get that, okay?
That's wonderful. Thank you, Your Honor.
Thank you, Your Honor.
All right. Okay, sure thing. All right. Well, we're all set for today then, and that's it. Thank you. Feel free to sign off if you like, Ms. Adams.
Thank you. Have a great day.
Okay, so let's see. Do we have anyone here in the cavalry case set for pretrial? Doesn't look like it. Perhaps Ms. Schaub knows whether that's been taken off the docket or not.
I'll check with her,
Or-
Judge. Give me one moment.
Okay, all right, thank you. So let's go to People versus Joshua Core. And I see Mr. Core is present with his attorney, Mr. Burdett. Mr. Chamberlain is here for the People. And this is the date for a preliminary examination in file 211582FY. So Mr. Burdett, what does your client wish to do?
Yes, Your Honor. I spoke with my client and we wish to waive the preliminary examination.
Okay, Mr. Chamberlain, are the People agreeable to waiver?
Yes, Your Honor. Thank you.
Okay, and Mr. Core, you wish to waive your right to a hearing? Mr. Core, can you hear me? Let's see what's going on here. Mr. Core, you're muted right now. There we go.
I can hear you. Yeah, I wish to waive the hearing.
Okay, so you've heard everything that's been said so far?
Yeah.
Okay. All right. And Mr. Burdett, no doubt, has gone over the purpose of today's hearing, discussed that with you, and advised you that to waive your right. Is that correct?
Yes, Your Honor.
Okay. Have you been threatened, forced, or coerced in any way, or promised anything to get you to waive your right to a hearing today?
No, Your Honor.
All right. So the examination is waived. The defendant is bound over to the circuit court to appear next on July 26th. And that is at 8 in the morning for a circuit court pretrial conference. Are there any issues we need to take up before the circuit court arraignment, Mr. Burdett?
No, sir, I don't have any.
Mr. Chamberlain?
Your Honor, thank you.
All right, so we'll continue the bond as is. And let's go to the circuit court arraignment. Mr. Burdett, have you advised the defendant of the nature of the charges and the maximum penalties? Any issues?
Yes, I have, Your Honor, and we'll waive any further reading of the information and enter a plea of not guilty and request a jury trial.
All right, so I will enter a plea of not guilty at this time. Is there anything else we need to take up today?
No, sir.
Okay, Mr. Chamberlain, anything else?
No, Your Honor. Thank you.
All right, well, good luck to you, Mr. Core. We're all set for today. Feel free to sign off.
All right, thank you.
All right, thank you, Your Honor.
Thank you, Mr. Burdett. Let's see. Ms. Castis, were you able to find anything out about the civil pretrial in Cavalry?
The case was scheduled. We've heard nothing as to a settlement or anything like that. So if you'd like, we could try to call the participants.
Well, perhaps we should just reset that. So, okay, we'll go ahead and reset that then, since neither party seems to be either aware of the hearing or maybe they've settled it. So,
Okay.
so maybe we'll hear something from them if we send out a new notice. All right, thank you. All right, now before we go, well, let's go to the Brown case. That is People versus Jacob Brown, file 211545FY. And Mr. Gerbeau is here on behalf of Mr. Brown. Mr. Hubble is here for the people. And let's see, do we need to have Mr. Brown here?
I would think so, Judge.
Okay, so he's in the jail, correct?
Correct. That's correct.
All right. Miss Odom, you want to get a message to the jail?
Yeah, I'll email Ms. Castis to call him.
All right. Are you anticipating any hearing today, Mr. Gerbeau?
No.
Okay. With regard to People versus Maria Garcia, that was also scheduled for a preliminary examination this morning, but I don't see Mr. Nichols, the defense attorney. Mr. Nichols, are you there?
There was some confusion with this case, I think. We thought that it was already waived. I just realized that, or likely realized that this document was never sent over to the court from 8th, and it's a waiver at the time for the preliminary examination. And so we had already talked about extending this out. And so I think that there's just been a bit of confusion between he and I regarding what we're doing on this case, but we wanted to extend.
So you want an adjournment of the preliminary examination. Okay, so what I'll look for is a stipulation from the parties then. I will go ahead and adjourn based on your representations today that you've discussed it with defense counsel, and both sides are desirous of an adjournment. There should be a waiver of the 14-day rule in the stipulation. Okay.
I just sent that over to Tammy. For the it's the waiver of time requirements signed by him. And then I believe that the probable cause sheet had a stipulation to adjourn on it.
All right. Okay. Thank you.
Thank you.
All right.
Sorry.
Let's go back. Yep. Let's go back to People versus Jacob Brown. Mr. Brown, are you able to hear okay? Oh, it looks like they've got you muted. No, there's no volume. Mr. Brown, can you say something?
Yeah, I can hear you.
Okay, good. All right, so this is the date and time for a competency hearing in file 211545FY, People versus Jacob Brown. Mr. Jarbo is here for the defendant, Mr. Hubble for the prosecution. And so give me just a minute here to look at the report.
I believe it was criminal responsibility. Isn't that correct, Paul? Not necessarily competency. Well, I believe what's up today is the competency exam. And there's a report, Your Honor, dated June 14th of 2021 from Dr. Rowland, ROWLAND. It should be in the court file. And we stipulate to the court reviewing that for purposes of criminal competency. I might have had it backwards.
All right, give me a minute to review the report. All right, well, I have a let's see. Yeah, I have the report from June 29th, which did not conclude that there was a lack of criminal responsibility.
Oh, that's what I have too. There was an earlier report dated June 14th, 2021, a separate earlier report.
All right, let me find that. Ms. Odom, am I missing something? I don't see a June 14th competency report. All I have is the June 29th report.
I think that's all I have as well, Your Honor.
Well, Mr. Jarbo must be special then, because he's got more information than I do.
Thank you, Your Honor. The report is addressed to the court and copied to Mr. Hubble's office. I'm happy to scan and email it forward. My assistant may have the file. Let me go check too, just to save you from that. I just remember one report, Paul, but let me check. I'll just be a second.
Okay.
Yeah, I'm not finding it either. I'm looking unindexed. What is the?
I have to have the report to make a finding. So
I do have two reports. I have one dated June 29th regarding criminal responsibility, and I have another dated June 14th regarding competency to stand trial.
He's going to get it to us. He has two, we have only one, so someone needs to email, if we're allowed to email that kind of a report, because or Miss Casti's give it to her and she can upload it in OnBase. So he can get that other letter.
I can do that right now. Tammy, which one do you need, the competency or criminal responsibility?
Judge?
He needs the competency one, Joe.
Yeah, I just scanned it into OnBase.
Okay, so if we refresh, maybe we can see it.
Yeah, give it a second, it should be there.
But it's competency, that's what you need.
Competency to stand trial, yes.
Okay, I'll give it to Tristan. He's walking it over right now.
I have it.
Thank you, Noreen.
Oh, you have it?
It's in.
Lord. Okay, so let's see.
Can you take it over to Noreen and see, please? Thank you.
Yep, we have it.
Oh, I guess they do have it. Okay.
Competency file.
It is. You want me to print it? Or do you want to
No,
find
that's
it?
okay. I just
Okay.
need to bring it up
All
myself.
right, and then you have the order for competency in your hands.
Okay, so give me a minute to look this over. Are the parties stipulating to the report?
Yes.
Yes, Judge.
All right, well, I'll go ahead and admit the report as part of the hearing. All right, based upon the finding of the examiner from the forensic center that Mr. Brown is competent to stand trial, I will make that finding today. And let's see. So the defendant is competent to stand trial. The case shall continue to the next stage of the criminal process, and that would be the preliminary examination. Are both sides prepared to go forward with a preliminary examination on our next criminal day, which would be July 30th?
I have two scheduled that date already, Your Honor, so I plan to be here.
All right.
Yes, Judge.
Okay, so that's what we'll do then is schedule. Is it likely that this hearing will go, and if so, how long would it last?
I think the court should plan on it proceeding, and I would anticipate 45 minutes.
Okay. Well, what do you think, Mr. Hubble? Do you think we need to put this out in the afternoon, or do you think 11 o'clock?
We have an afternoon.
We have,
Yeah,
as I
that's-
indicated, Your Honor, we have two lengthy prelims already for that date. So
At 1:30.
Oh, so 11 o'clock will work the best.
11 o'clock, we also have two prelims. I don't know if they're going.
All right, well, it'll be a busy day, so we'll have that at 11 then. So is there anything else we need to take up today?
No, Your Honor.
No, thank you, Judge.
Okay, thank you both, and we'll see you back then on the 30th, Mr. Brown.
Thank you, Judge.
Thank you, Judge.
Yeah, you're free to go, Mr. Brown.
Thank you. Sorry.
All right, thank you, Ms. Castus, and Mr. Chamberlain, Mr. Hubble. We're all set this morning. Yep, you too. Have a nice weekend, Noreen.